Welcome to the Future of Resolution, Miles Mediation and Arbitration's podcast. I'm one of your hosts, Marcie Dickson. Thank you for joining us for our first segment. On today's show, we have the founder and CEO of Miles Mediation and Arbitration, John Miles. John, thank you for being here. I can't think of a better way to kick off our podcast series. When we discussed the idea of producing a podcast, we were excited about the possibilities, particularly the opportunity to hear the stories of those within the legal community. There are so many people out there engaged in meaningful activities that influence our community every day, and they deserve a platform to be heard. John, we recently rebranded. Can you discuss the process, what actually led to the decision to rebrand the company? What does it represent? What does it signify? And what's next for Miles?
Yeah, well, about everything has changed and for the better. When I started the company, it really was, me and my truck. And I was not only trying to build my mediation practice, but I was trying to educate the legal community about what mediation was. Obviously, mediation has taken off. And Miles has too. In the early years when I was adding mediators, almost everyone that I added had a background in personal injury litigation. And candidly, I would say it until about January of 2015, we were primarily a firm that mediated personal injury automobile accident cases. As that began to change, it became apparent to me that we needed to rebrand ourselves to better fit what we were becoming and what we hope to be.
So John, even beyond the actual rebrand of Miles, you wanted to accomplish something much larger, and that was to have an opportunity to actually challenge the way alternative dispute resolution is perceived on a much larger scale.
Yeah, that is true. Again, when I started out in my practice as a mediator, mediation was in its infancy, and indeed it was an alternative to traditional litigation. But the attorneys were the ones who decided when that option was to be used. Probably beginning, I would say, in the early 2000s, the judicial branch, the judges, really started to get behind mediation. And one of the primary reasons for that was court calendars were growing to the point that it became harder and harder to get a case to trial. And our resolution rate here at Miles on the date of mediation is a little over 70%. So obviously, if a case was ordered to mediation, there was only a 30% chance that it was going to return to the court. And that made a lot of sense to judges. But so they were ordering cases, judges were ordering cases, but the litigators, the attorneys who practiced, were not as inclined, I think, to perceive themselves as compromisers or as people who availed themselves of this alternative. They saw themselves as trial lawyers who battled for their clients. I want to disrupt that. I want to make ADR seen as the primary destination for litigants and for attorneys. And I think that it makes a lot of sense because it can help attorneys professionally. They will have happier clients and they will be able to, I think, deliver what those clients need. And in addition, I think that we will be able to obviously provide what litigants want.
So where is the disconnect? As ADR started off as a true alternative to the litigation process, another avenue for litigants and for parties in conflict to explore different paths to closure. What happened along the way? How did it become this process that people don't necessarily take seriously, or they don't recognize the power within ADR? What happened?
Well, I think it's a matter of time and money, really. When I started practicing law in the 80s, you could have a case filed and get it to trial within a year. So litigants were able to engage in a dispute and have closure quickly, and the financial costs were modest, relatively speaking. As the population of Atlanta and Georgia grew and the civil filings increased, it became more and more difficult to achieve closure. So I think the rise of ADR, it made sense for economic reasons and for time. What I think was missed in that, at least what I believe and am trying to communicate to the legal community, is that truly mediation in particular, but ADR in general, is the preferred avenue, because there are things that can happen within the context of a mediation that can't happen at trial. And while it benefits attorneys for reasons I can go into later, the ADR, I think it's the answer for most litigants. It is the better option, I think, than traditional litigation.
John, in 2012, you wrote your book, A New Day in Court. Can you tell us about your findings? You did research in preparation for the book. What did you find? What was the feedback that you received from litigants that you'd mediated with?
Well, yeah, that was actually very interesting. It was early, or relatively early in my career as a mediator, and I had been approached about writing something about mediation, and it's really difficult, I think, although I'm sure others have done it very well, to write a how-to book on mediation. So when the folks who asked me to write the book approached me, they said, well, we kind of have that. We have the how-to books. We're more interested in why people come to mediation and what motivates them to settle. And I told them, that's easy, it's money. Because that's what I truly believed at the time. And they said, well, maybe. So we developed, had a company help us prepare survey questions. And I had identified 4 possible mediators. Again, I thought, of course, money is going to be the primary motivator. But I said, well, people could also be motivated by anger, a desire for justice, or fear. So the 4 were money, justice, anger, and fear. And we developed questions, and we surveyed people who mediated at Miles for the calendar year 2010. Everyone, attorneys, corporate reps, and plaintiffs. And what I found after doing this for 3 months, I went back to the people who'd written the questions, and I said, these questions aren't right, because I'm finding that money is really not what this is all about. And since I believed that it was, I said, you got to rewrite the questions. So they tinkered with the questions. We did the surveys again a month later. The percentages hadn't moved at all. So the questions weren't the problem. The problem was my assumption. And my assumption that it was all about money was absolutely wrong. What we found that the majority of litigants, attorneys and parties, but particularly parties, are not motivated by money at all. That their motivations have to do from emotional response to either being sued or being injured and having to sue. And that was quite an eye-opener for me.
Is that perspective that litigants are motivated by money? Would you say that that's shared amongst the plaintiffs and defense bars?
Yes, I've had opportunity to speak to a number of groups over the years, and while I think that most attorneys, whether they be on the plaintiff side or the defense side, would say, oh, sure, certainly there is an emotional component. I think many believe that it really is about money. And I think that that's where the notion of valuative mediation arose, a sense that the primary role of a mediator is to come in and say, hey, I've been there and I've done that, I've gotten the T-shirt, and I can tell you either as a judge or as a lawyer that if you try this case 7 out of 10 times, this is going to be the range of verdict. And if this process was really just about money, that would work 100% of the time. But what I found was that if you lead with valuative for particularly an injured plaintiff who is not motivated by money, you're going to be spinning your wheels, because that is not why those folks filed suit. It is certainly not why they find themselves here at the table. And if you keep trying to hammer them with a dollar figure, you can actually leave parties worse off than they were when they came to the mediation.
John, for neutrals who've undergone traditional ADR training, their mediation style is typically a combination of evaluative, transformative, or facilitative. However, at Miles, we talk a lot about the fact that our neutrals are intuitive and employ a unique approach while mediating. What are your thoughts?
Because of my research in writing the book and what I was able to share with the neutrals who have associated with Miles, I have found that there is a skill set, and it's much more intuitive, I think, as you said, than it has to do with a process that can be taught and memorized. Much like a conductor of an orchestra, they know when to bring up the horns and when to allow the strings to participate, and they are able to orchestrate the process. The other thing that you touched on in your question is that all of those approaches that you talked about have to do with what happens within the four walls of the mediation. I think that that's too narrow a view of what we do and why we're successful, certainly here at Miles. From the time a customer enters our facility to the time that they leave, the entire experience has to be such that it's conducive to compromise. It's conducive to communication, to finding resolution. So from the staff that we employ, to the way our offices appear, to the food that we serve, to the respect that is shown to people who come to our offices, that's what I think leads to more success at Miles. That comprehensive, that holistic, if you will, view of what happens during the mediation process.
We've spoken a lot about what the future of the ADR industry looks like offline. Can you share with us what your vision is for ADR?
Yes, this comprehensive approach that I talked about earlier, where we view the service that we provide as something that begins from the time they walk into from the time they schedule, the interaction they have with our case managers, through the time that they leave, is something that no one else in the industry is doing right now. And I want to take that national. I want the Miles brand to represent that comprehensive approach to resolution. And that is realizing that I needed a rebrand, to rethink, to reimagine, if you will, the way that we project ourselves in the legal community. That was necessary to get us to what I would like to be, which is a national brand with offices throughout the country.
I mean, I think it's safe to say that for litigants and for parties who are even pre-suit or even attorneys, maybe they don't fully recognize the value of ADR. If there is something that you could share in terms of the true power of exploring ADR as an avenue to resolution.
What I would say to people when they've been injured and they want their pound of flesh, or someone who's been sued and been told that they had done something that was harmful, I would say, what is it that you really want to accomplish? And don't get me wrong, there are some cases that absolutely have to be tried. There are some disputes that demand a jury's attention. But for most disputes, I think what most people would say is, look, if I'm the injured party, I'm not trying to win the lottery. I don't want to be taken advantage of. Or if you are the person who's been sued, look, if there's something I did, if there's some way to make this product better, if there's some way to manage the way that I operate my vehicle in a way that is safer, then by all means, let me know that. But most people just want to get back to their lives. They want to get back to what they do. Mediation, ADR in general, particularly mediation, allows for them to reach that end at a fraction of the cost, with a fraction of the investment of time and of effort. And I think that if people that could be communicated effectively to folks, they say, well, of course, that's the path I want to go down. I don't want to go through 2, 3, 4 years of litigation. I think if you were to ask most people who have been injured and file a lawsuit, they're not looking to win the lottery, but nor are they looking to be taken advantage of. And if you ask most people who have been sued, especially if they acknowledge that they had done something wrong, they understand that at some level there's going to have to be some economic resolution. Most people would say, I would prefer to go down a path where I spend, a fraction of the cost of litigation and get to have control over the outcome. And given a moment to weigh the options of litigation versus ADR, I'm confident that most litigants would choose ADR.
Absolutely. It sounds like that's where the disconnect is, the information getting to the litigants that they really can take control of their disputes and that they can reach closure faster, certainly in a more cost-effective manner through mediation, through ADR.
And I think that is the future of resolution. The future of resolution is carrying that message to the decision makers and allowing them to avail themselves of ADR, or said this way, that ADR becomes the goal as opposed to an off-ramp on the litigation process.
And this is certainly something that could spread throughout the country. I mean, I think that there's this sort of deficiency within the ADR industry is not unique to Georgia or the Southeast. It's something that should change on a much larger scale.
Absolutely. I think if what I've said about the motivations of litigants is accurate, and I believe that it is, then there's no part of the country that, again, if those litigants are given that option, aren't going to choose ADR over traditional litigation process.
Well, that would lead to a sea change for our legal industry. What would that mean for the way justice is served?
I think it can mean a number of things, but certainly, as you allude to in your question, people have a greater satisfaction with the legal process. And I think that in and of itself, if nothing else were to happen from ADR, having the public be able to have a better view of how we dispense justice is of enormous import.
Thank you again for joining us for our very first segment. We hope that you will join us again for our next show with Jennifer Grippa and Steve McKinney, who are both neutrals with Miles. They will be on discussing the arbitration bias.
That was great, Marcie. Thanks.